So to just some background information for our viewers who are joining, because I still see some ladies joining us as we speak, is this will be our last Instagram feed for 2021. I'm very grateful to the ladies who've participated so far. And just to let our viewers know, as well as the ladies who express interest in our activities, that in 2022 we'll have our first physical meeting, which will be at the end of February. And the venue will likely be Helani Golf Club. And the discussion that we will be having for the day will be on toxic relationships. So be sure to join our Instagram account. If you know other ladies who would be interested in the kind of topics that we cover, please encourage them to actually get on board the Instagram account. And our website will be launching in December of this year, where we will be putting up our monthly meetings as well as potential retreats for ladies. So our 2022 retreats will focus on things like burnout, femininity, what it means to be feminine, trying to be a better version of yourself in a myriad of different ways, as well as topics such as healthy relationships, and even dealing with trauma. We'll be doing various sessions on trauma management through retreats and through our physical meetings as well. So we're very excited about that, and I still see quite a few ladies joining as I speak. So I think to start off with, since it's already just after 6, is I'd really like to introduce my guest. Her name is Helani van Westhuizen. Helani is not only one of my briefing attorneys, she's also a very, very dear friend of mine. And I've invited Helani to speak tonight, given that it's our last meeting on a very special topic that's very close to her heart, and that is on child law. Welcome, Helani.
Thank you. Thank you, sir, and thank you for having me. Vice versa.
Helani, I think while everyone is just joining onto the link, let's start with your background. What is your background broadly?
Okay, I studied at the University of Stellenbosch up until 2008, and then I commenced my articles in Johannesburg from 2009 onwards. I was admitted as an attorney in 2011, and then I started with NLA in 2012, and from there I've kind of like broadened my expertise in family law and became a mediator and a notary, and
And what really sparked your interest in child law? What was the passionate drive that made you go into this specialized area?
Okay, so I think this already started at university level. I had a fantastic professor, Professor Helani, who made family law like the best and most interesting subject. We couldn't wait to get to class, and back then that already sparked my interest, and from there I just took interest in it. For me, it's about a personal relationship with everyone you're dealing with, and that is what makes it so special, and to make a difference in people's and children's lives.
Yeah, fantastic. So, I mean, when you talk about child law, I think that for our viewers, I know some of them don't have any legal experience. We know as legal practitioners, Helani and myself, that we actually have a fundamental right afforded to children in our Constitution, and Helani and I were talking about it before we came live. And that's Section 28 of our Constitution, which I'll read now. Every child has the right to a name and nationality from birth, to family care or parental care, or to appropriate alternative care when removed from the family environment, to basic nutrition, shelter, basic healthcare services, and social services, to be protected from maltreatment, neglect, abuse, or degradation, and to be protected from exploitative labor practices, not to be required or permitted to perform work or provide services that are inappropriate for a person that's a child's age, or place at risk the child's well-being, education, physical or mental health, or spiritual, moral, or social development, not to be detained except as a measure of last resort, in which case, in addition to the rights a child enjoys under sections 12 and 35, the child may be detained only for the shortest appropriate period of time and has the right to be kept separately detained from persons over the age of 18 and treated in a manner and kept in conditions that take into account the child's age, to have a legal practitioner assigned to the child by the state, and at state expense in civil proceedings affecting the child if substantial injustice would otherwise result, and not to be used directly in armed conflict and to be protected in times of armed conflicts. The child's best interests are of paramount importance in every matter concerning the child, and this section, child, means any person under the age of 18. So, Helani, those are very noble rights. Can you explain to our viewers, what's the prominent piece of legislation that actually comes from Section 28?
Okay, that would be the Children's Act, a wonderful act, and it's a wonderful piece of legislation. And the most prominent thing in Section 28 is the child's best interest is of paramount importance in every matter concerning the child, and that is what our Children's Act was kind of also built on. And Section 28 sets out certain rights for children that assists us immensely, for example, in undocumented children, refugee children, anything like that. And then also, the question then becomes, how do you determine what is in the best interest of a minor child? And so Section 7 of the Children's Act then sets out a kind of list, like a checklist, in terms of how you decide what is in the best interest of a child. And so that can range from the relationship between, for example, a parent and a child, or between a child and extended family members, whether there's violence in the house, whether the child has a chronic illness or some kind of disease. So kind of like a whole checklist.
Fantastic. So
that
sounds really quite like, once again, they're very noble factors. And just explain to our readers, before we get into the practical reality of whether or not that really exists in reality, or whether that's just more like paper law, and we'll share some of our experiences with you shortly, but explain to our readers who are not, again, familiar with law, Section 18 and parental rights and responsibilities, because I think each parent they don't really understand the concepts of parental rights and responsibilities. It's pretty vague to most people when they start with children's matters or litigation in a divorce setting. Just explain to our viewers, what are Section 18 parental rights and responsibilities?
Okay, so Section 18 sets out, what is parental rights and responsibilities, and that means that you have to maintain the child, that you have to act as a guardian for the child, to have contact to the child, and there's another one.
There's the care of the child.
And to care for the child. So caring for the child will mean like the child's day-to-day needs, for example, placing the child in a good school, looking after their daily needs, for example, providing food to them, clothing, that type of thing. And to maintain the child will mean to pay for the child for certain things. So many people think that, they can have a child, but it's not really, law for them to maintain a child. And that is incorrect, because if you want parental rights and responsibilities, the Children's Act says that you have to maintain the child, even if it is at a minimal value, but it is necessary.
Yes. So another problem that we sometimes encounter as well as practitioners in family law is that some parties will say to us, well, I don't get to see my child, so I don't need to maintain my child. And that is a serious misconception of parental rights and responsibilities. And I think as well, if you can then just indicate to our viewers, what does guardianship look like? I mean, what is that from a legal perspective as well, before we move on to the voice of the child?
All right. So every parent is a guardian, but every guardian doesn't need to be a parent, if I can say it like that. So the Children's Act set out, parental rights and responsibilities, which goes to a guardian officer. So when a parent must be a guardian to a child, but that does not necessarily mean that a guardian needs to be a parent. Certain parental rights and responsibilities can be awarded to someone else outside of being a parent. So, for example, to a grandparent who wants to have contact to the children, or is maintaining the child by paying school fees. That I get a lot. Then the court will assign certain parental rights and responsibilities to that grandparent, for example.
Fantastic. So I think also just in line with what Helani has indicated, that these parental rights and responsibilities can also be awarded to third parties. For example, a grandparent or someone who expresses an interest in caring for the child. Guardianship per se is the ability to oversee the contractual provisions of a child, basically. So, for example, to sign for passports, if the child needs to have a change of name, if the child needs to go overseas, which can become extremely contentious in highly contested divorces. So that is what the nature of guardianship looks like. But I think, Helani, then if you can explain to our viewers as well, this notional concept in the Children's Act of the voice of the child, that the best interests of the child must be considered, and if the child is of a suitable age, then the child's views must be considered, and it's peremptory, it's directive in terms of our legislation. What does that actually mean?
I'm going to get to that question now. Just with regard to guardianship, I could just give a quick example of a case I had, for example, and this is quite common actually, where parents get separated, and one parent is in one country. In our matter, I remember he was in Australia, and the mum was on this side. The biggest concern sometimes is if the child needs a blood transfusion or needs hospitalization or things like that, then both parents need to consent to that if both parents are here. But given the fact that one parent might be overseas or you can't get a hold of them or anything like that, you can bring an application to court to award guardianship only to one parent, but then for the other parent in the other country, for example, to still have parental rights and responsibilities. For example, to maintain contact with the child, to pay maintenance to the child.
Fantastic explanation. Thank you for the practical example. So if you can just explain to our viewers about the voice of the child. Thanks, Helani.
Okay. Section 10 of the Children's Act gives every child a right, when there's any matter affecting them or their well-being and their care, to have a right to voice their opinion and their feelings and their wishes with regard to that matter. And so child participation is very real in our country especially. For example, the family advocate won't do any kind of report if they haven't seen a child. To have an interview with them, to see what their views and wishes are, and so on. However, this depends a lot, and the Children's Act states it very clearly, that the age, the maturity and the stage of development of the child must be taken into account. For example, a 2-year-old child won't be able to, vocalize exactly what their wishes or feelings are, but, a 3-year-old child might be able to draw a picture of how they feel, etc., where a child of 10 years or older, what we experience usually, is very vocal about what they want, what their wishes are in a specific matter affecting them. It's not to say that will be taken in, that they will be given their wish, but the Children's Act tells us that it must be taken into account.
So also just to, bring in some practical experience in terms of what Helani is saying, is that, Helani talks about the family advocate, and that is a state-run kind of forum where divorcing parents in particular will go and be assessed by an advocate, basically, and a social worker. They're called family advocates. It's free of charge. And then the family advocate will produce a report to be of assistance to the court. I must say that as someone who's appeared quite frequently in unopposed divorces, it's very rare, besides the family advocate's report, for a judge to take a parenting plan, which is generally the plan that kind of oversees care and contact and guardianship at the end of a divorce, for a judge to say to me, has the child actually expressed a view on the parenting plan? And I think that is a fundamental shortcoming in the process that we have. It's a little bit of a tick box exercise. It can become quite superficial. And I know that in Australia, what we call child-centered mediation has become extremely popular, and it's very much far more regulated than in South Africa. So there are shortcomings insofar as the noble law compared to the practical reality.
This I can say, so the last year or so, the family advocate are quite strict when they do give their report at the end of a divorce, or when you submit the settlement agreement to them, that there is a specific clause in the settlement agreement that agreement has been discussed with the children, with child or children, but it might be a tick box, so they're not really sure whether it's been done or not.
So, Helani, explain to our viewers then, there's the Children's Act makes provision for what we call children's courts, which are lower magistrates' courts, and then the High Court, which is the upper guardian of all minor children. Just explain to our viewers, what does those two processes look like generally in practical terms?
Okay, the children's court, I would say, gives one easier access. For example, it's much easier for a parent to go to the children's court and to institute a matter themselves. When the High Court, it's a much more difficult thing to do. So in the High Court, you would need legal advice and need a legal representative to represent you in court. Where the children's court is easier to access in that way, especially with regard to maintenance and that type of thing. Any person can really institute that. What I found is that obviously the High Court don't really deal with maintenance. They usually put that down to the maintenance court. The problem with the children's court, which we've experienced, is that sometimes you'll get a magistrate who's been, in litigation, coming down to the children's court to make some orders. He's got no clue about the Children's Act. There's nothing regulating it, and so forth. So my likeness is rather to institute matters in the High Court. No, it is done correctly. We've experienced a lot of problems with fraud in the children's court, and those matters had to be taken on review in the High Court, which cost the client eventually 10 times more. Personally, for me, I would prefer the High Court, but there are new regulations coming out in terms of the Children's Court, which we are very excited about, which will regulate the whole process of the Children's Court. For example, social workers will now be forced to submit reports within a certain period of time, for example, 30 days. And if not, they have to come to court to explain exactly why they haven't submitted it. So it will regulate the Children's Court in a much, much better way, and I think that is going to make the difference.
Fantastic. So just in line with some of the inputs from Helani, which have been great, the Children's Court is very, very informal. As Helani says, you don't need legal representation. They're closed courts, so generally speaking, parties are taken into kind of a small office type setup. There's no stenographer per se. That the magistrate will usually take the record in writing. And then generally speaking, in the magistrate's court, there'll be a separate room for children to be interviewed, which is supposed to be a lot more child-friendly. There'll be things like teddy bears. Sometimes in the good children's courts, they even go so far as to have therapy dogs for children. So they have animals that are dressed up as magistrates in order to make them feel a lot more comfortable in the court setting, which is supposed to be far less imposing than a high court, when a high court judge might ask to see the child, and it might be quite intimidating. But as Helani says, that there are several problems with the children's court. I find that with my clients, many of them say that a fundamental flaw is that they feel like there's no quick finite resolution. You file a matter with the children's court and you've got to go back again and again and again and again and wait for the family advocate's report and wait for a social worker's report, and they find that is very emotionally exhausting.
And much more expensive to the client.
Yes, eventually. Yeah.
Exactly.
So I think that both forums have their difficulties, and it would be very nice if the children's court could remedy certain shortcomings. But that being said, as against the ethics, and we've talked about fraud, I mean, you and I have had matters where there have been implications of magistrates and children's court who've potentially taken bribes. We've had to take it on review. I mean, we've had some horror stories. That being said, share with our viewers, what is the role really of legal representatives as well in terms of safeguarding the best interests of children?
So I would say that every legal representative is also bound to the law, and that means bound to what is in the best interest of the minor child. For me, that is a matter of ethics, to not only just take instructions from your client on what to do and this is what they want, but to get behind the story, to find out why they're feeling like that, to encourage contact with other parents, to advise them correctly. They will come to you and say, this is how I want it done, and to advise your client correctly in that regard. And as I said, to encourage contact, to encourage to focus on the child when doing a settlement rather than to focus on their own personal needs or any grudges that they might have against the other parents.
Yes. So, I often say that 99.999% of problems with co-parenting is always communication. And that's also why we started this kind of platform, is to enable and empower our ladies so that they can become better communicators with their husbands and their spouses and their partners, and they can also demand better communication from their other halves. They know what good and healthy communication actually looks like. So just explain, Helani, then from a child's view, I mean, how are children actually really impacted during a high conflict divorce? I mean, what do they experience in your experience?
Okay, so firstly, I always say to my clients, that where in the past there was one home, there is now suddenly two. So that is the major thing that affects the children is a new environment in both homes. Half of the furniture might be gone, or they now have to travel with a backpack from one parent to the other when it's time to have contact with the other parent. So my advice is always to make sure that the child feel at home in both homes, so that they have their own room in both homes. I've had parents that went so far working together in creating rooms that are kind of similar for the child in both homes. And not to let the child move every time he goes to have contact with the other person, with all his school clothes, his food thing for school, and school clothes and toothbrush, but rather to keep it, like that the child has in each home. It feels like home. They've got clothes there, they've got school clothes there, they've got everything that they need there. So with a perception
more of a healthy situation.
Yes.
And I think also tying in with that, what we've seen, and in line with the view of the child, what we've seen develop after 10, 11 years together is a very unhealthy phenomenon where parents kind of put extreme pressure on a child in that voice of the child assessment to be the decision maker. So in other words, you'll find that respective parents might bribe the child or try to ingratiate themselves with the child, so that the child can give a better view of mommy or a better view of daddy in order to determine things like primary residency. And that is, we'll get to parental alienation now, but that is very unhealthy for the child. And it places an inordinate amount of pressure on the child to kind of become the umpire of a divorce and to take on huge adult decisions that really children shouldn't actually have to take on.
I think what I also see a lot is children feeling guilty leaving the one parent to go to the other parent, and that's usually the parent causing that. So making the child feel guilty about leaving, where they should be encouraging the child, to go. Then I also just want to highlight, it might be very much different in a situation where a child might be abused by one of the parents. And in that regard, I would say, that child be taken, to the police station and to a doctor immediately for them to fill out a J144, and then for an urgent application to be brought in order to stop contact. So as much as we encourage contact, it's also very important to be aware of any abuse going on, and that can be psychological abuse, physical abuse, emotional abuse, that type of thing.
Fantastic. So, as against that context of abuse, and also just kind of putting the toxicity of the divorce, or even children born not in a marital situation, but putting the acrimony on the shoulders of the child. I mean, what mechanisms are there available besides the ones that we've spoken about to actually directly protect the child during that adversarial process?
So my view in that is always to get a report done by a forensic psychologist. So firstly, I feel like it's a very weak spot, in our law is parental alienation, and but my experience with that is that even though sometimes I have a matter now where the family advocate has actually just given a blind eye and just said, I'm not assisting in this matter anymore. So the experience is that it's best to get a proper forensic report done so that any kind of alienation can come out in that, and then you use that in order to protect the child. Because it's wonderful to make averments, but the truth of the matter needs to be established, and that is usually the problem, and it takes long. But obviously, if there's any major concerns like abuse or things like that, an urgent application must be brought in and contact staff.
So just to also carry on from that thought of a forensic, so that will generally be from a psychologist or a psychiatrist, or a social worker, a forensic social worker, and that investigation is far more detailed than a family advocate's investigation. The downside of that is that they are sometimes prohibitively expensive. And that is a common complaint. It seems to be that sometimes with parents, justice is a very expensive exercise. But for something like parental alienation, you do need a proper forensic, because you need someone to also interview the child in their homes, in the respective home settings. And for our viewers who don't know what parental alienation is, according to medical journals, and it's now recognized as a medical condition, the concept of parental alienation was first put forth by Dr. Richard Gardner in 1985, and parental alienation primarily occurs during high conflict divorce in which the child identifies strongly with one parent, usually a custodial parent or someone who has primary residence, and the other parent is hated and rejected without any justifiable reason, such as abuse. The alienation is engineered at the hands of the alienating parent, who often pressurizes the child to go along with their hatred of the other parent. And the alienating parent programs the child to despise their other parent by criticizing the alienated parent and interfering with a parenting relationship. While the alienated parent obviously suffers in the situation, the child does so as well. The child experiences the loss of their alienated parent like they would a premature death of a parent. And the child is also likely to feel neglected and angry. They may take on traits of the alienating parent, such as a lack of empathy and rigid thinking. So this is actually, there have been several studies in parental alienation. In extreme cases, what Helani and I have experienced is it will start with, a light form will be bad-mouthing, guilt-tripping, expressing a kind of a reluctance or a resistance to allow the child to have contact with the other parent in a variety of different ways. And then there are extreme forms where parents, I had one instance where a mother actually falsely accused the father of sexual abuse. And it was a complete, there was overwhelming evidence that she had actually engineered the entire thing. It was a false allegation in order to get the kind of contact that she wanted during a divorce. So there's a very dark side to parental alienation, and it's actually a form of child abuse at the end of the day. But that being said, Helani, is there any specific legislation on parental alienation?
No. And that's the short answer.
Yeah.
And while you were reading that out, I also saw somebody described it as the psychological manipulation of a child into demonstrating unwarranted fear, disrespect, and hatred towards another parent, towards the other parent or family members. And as you said, it is absolutely a form of abuse. But the problem is that it's still very weak in our system, in our law system, And where other countries like the US is much has progressed, a lot, and have certain laws in place for this. But currently, there's nothing
specific.
Nothing specific.
But what we have seen over the last decade, Helani and myself, is that if it's a situation where a High Court judge in particular finds that there is parental alienation, you will find that judges tend to take a very swift stick to that, and the alienating parent tends to lose contact with the child and is actually afforded then what we call supervised contact. So the visits are supervised by a social worker or a family member. But it usually takes a long time to actually get to that process, and in the time frame, the wreckage is actually the child. So it's a very sad situation, and I think that we also need to just be honest with our viewers, which is that the law is a very blunt tool to fix very broken situations. So sometimes the damage is so acute and your court order just comes too late. And that's why I say from the outset, it's more important to kind of deal with healthy relationships from the outset and a healthy divorce. Because I think that is why there are certain attorneys that I really love dealing with. I mean, Helani is one of them. Kate Patterson from Livingston Crichton is another one who I trust implicitly because I know that they have the best interests of the child at heart. And there are certain litigation teams where it's their model to actually escalate the litigation between the parties. So I think that parties also need to be very acutely aware of trying to adopt a practical and conciliatory approach when it's needed, rather than just bulldozing your partner in the hope of actually, attracting brownie points and at the cost of your child.
I think on that point, Sam, what I do experience if I get family advocate reports back is that they do pick up on it. So most of those social workers are trained, to recognize things like parental alienation in children, especially because they interview all three parties. And then they are against it, although there's nothing in our law stating it. But I've had very favourable outcomes from the family advocates reports on that.
Fantastic. So again, another mechanism or oversight which Helani has been mentioning is the impact of social workers. A good social worker can really make or break a case.
Absolutely.
Bad social workers, I think they do more harm than bad magistrates and judges put together, in the sense of the harm that they can do to a matter. And there are unfortunately bad social workers out there, as you and I have experienced. So that's another realm that we could discuss ad nauseum, which we will in due course, perhaps in 2022. Then just take our viewers through, one of the second last topics, which is your work, particularly with adoption and the ancillary side issue of fostering, but mostly adoption. Just take our viewers through that process as well.
Okay. I haven't been working on adoption for too long, but I can say that we only kind of get involved in the process if anything goes wrong. The most important thing is that the child must be certified, shall I say, adoptable. So that means that there must be a report from the social worker to say that the adoption is in the best interest of the minor child and that the child is adoptable, and also that all the regulations of the Act has been followed. Now the question becomes, when is a child adoptable? And the Children's Act section 236 sets out certain criteria for when a child is adoptable. For example, the child is an orphan, the child has been completely abandoned, the child, or maybe, for example, the parents have given consent for the child to be adopted. So there's various criteria for that. But then the Children's Act goes further, and it says that if you want to adopt the child, there's a list of criteria that you yourself have to obliged to that. So, and what they really need to determine is whether you're a fit and proper person. Obviously, a person who's got a record of sexual abuse won't be able to adopt a child. But it's a very interesting process, and it's an opportunity to make a difference, not only in the adoptive parents' lives, but also in the child's life.
Yeah, I think as well, it's also a very controversial area of our law. I mean, as Helani and I have experienced, some people say to us, South Africa is a wonderful country, but it's not a country that cultivates fostering and adoption, which I think is to our poverty and to our detriment. And then lastly, Helani, just on our last line of discussion this evening, if you can speak to our ladies about, given the damage that can be done in highly adversarial divorce and relationship settings, and I know my last interview was with Chantal Kerr, who was fantastic, and she has exceptional experience as well in mediation. I mean, just talk to our ladies about the role of mediation and coaching as well, one-on-one coaching in high conflict divorces and family litigation specific to children.
Okay. I think mediation is a fantastic tool in order to get people to get to a settlement. Then we talk about child-centered mediation, where that is a process, a mediation process, in which the parents are kind of forced to focus on the child rather than their own needs. And that usually brings them to settlement. And through that process, the child can also be interviewed. But I always say, that must be done by somebody who's qualified. So I myself, as a mediator, won't be qualified to interview a child. And that is usually outsourced to a social worker, or psychologist, or somebody that can assess the best interest of the minor child, but also the child's views and wishes. And that you bring into the mediation process, to say to the parents, but this is the wishes of the child, or their heart's desire. And that, when you get them to focus on the best interest of the child rather than their own interest, it makes a huge difference. And now, as you know, you have to request another party to mediate before you can go to court on any matter. And I believe it's fantastic, and that's the way it should be. Yeah. Otherwise, courts will be inundated with applications where simple things could have been settled in mediation.
Yes. And obviously litigation is very expensive, and it's very emotionally draining, and as I said, the only loser really at the end of the day usually is the child. I think also, just to end off, I've experienced certain child-centered mediators where it's not just a situation of two adults sitting across the table and developing issues in a very adulty way. They generally have profound experience with play therapy, getting children to really communicate in their own little children's language, so that they feel like their voices are heard in a very safe way. And I think that's also another important aspect, just to end off, in the sense of the child's views, because what Helani and I have also experienced is that sometimes children will express a view to a social worker or a play therapist, and then those views are, sometimes the child is punished. The parents find out that the child has expressed a view, and then the child is actually punished for that view. And that completely and entirely defeats the purpose of the child expressing a view. So I know some play therapists, for example, refuse to disclose any underpinning interviews with a child, and that is to respect the integrity of the child and the autonomy of the child, that the child can express himself or herself in a safe way. I'd like to really thank Helani for taking the time.
Thank you for having me.
And I hope that our viewers have enjoyed our very last session for 2021. This video will be made available on YouTube. I'm hoping I get it right this time. And thank you very much for joining us this evening.